Welcome to the overview of the legal system of England and Wales. In this lesson, we will provide a comprehensive look at the structure and function of the legal system. We will cover the primary sources of law, including legislation and judicial precedent. You will also learn about the hierarchy of the courts and the roles of legal professionals. By the end of this lesson, you will clearly understand how the legal system operates. Let's get started with an introduction to the basic concepts and critical components. First, let's define the common law framework. This means that much of the law is developed through decisions made by judges in court cases rather than solely based on written statutes. This system is characterized by adjudication based on statutory provisions and judicial precedents. In other words, while statutes state the law, judges' interpretation and application shape the common law. The common law system allows flexibility and adaptation, as new precedents are set with each significant court decision. The legal system in England and Wales is adversarial. This means the parties present their arguments and evidence to a neutral judge. The judge acts as an impartial arbiter, ensuring that the trial is fair and that the rules of procedure are followed. This contrasts with the inquisitorial systems found in continental Europe, where judges take a more active role in investigating the case. In the adversarial system, the case's outcome depends on the quality and persuasiveness of the arguments and evidence presented by each party. Let's examine the sources of law within the legal system of England and Wales. Statutes, recognized as Acts of Parliament, form the cornerstone of legal legislation. Key components of a statute include the short title, long title, date of royal assent, preamble, parts, sections, subsections, extent, and enabling provisions. Subordinate legislation, also known as secondary legislation, empowers a designated body to create regulations that actualize the intent of the Act. International treaties are agreements the government can commit to through the royal prerogative, impacting domestic law. Case law, which integrates statute and judicial decisions, plays a fundamental role. Binding judicial determinations contributes to the development of common law. Authoritative texts aid in statutory interpretation but are less common than civil law systems. Additionally, conventions, part of the unwritten UK Constitution, represent established practices recognized and adhered to, though not formally obligatory. These sources shape the legal framework, ensuring a comprehensive and adaptable law system. Let's explore linguistic rules, interpretive presumptions, and interpretative assistance. Interpretation of legal texts considers the entire context, utilizing legal maxims and certain presumptions to understand the intended meaning. Judiciary interpretation is often aided by intrinsic aids, which include the statute's text, and extrinsic aids, which are external sources like legislative history and prior case law. These tools help judges and legal professionals apply the law consistently and fairly, ensuring that statutes are interpreted in a way that aligns with legislative intent. Understanding various types of laws and their classifications is important in the study and practice of law. Public law governs the relationship between individuals and the state, while private law deals with relationships between private individuals or organizations. Criminal law involves laws related to crimes and their punishments. Civil law, on the other hand, covers disputes between individuals or organizations. Substantive law defines rights and duties, such as crimes and punishments in criminal law. Procedural law outlines the steps and processes for enforcing those rights and duties. These terminologies form the foundation of legal knowledge, helping legal professionals navigate the complexities of the legal system. Let's delve into statutory interpretation. The process of statutory interpretation involves several key principles and methodologies. First, we have parliamentary sovereignty. This principle emphasizes that statutes are the ultimate authority in the legal system. Parliament's laws are supreme and must be followed. Next, we consider the role of the courts. Courts are responsible for interpreting statutes and secondary legislation. Their goal is to infer the intended meaning of Parliament when the laws were enacted. Finally, we look at the interpretive methodologies used by the courts. These include the literal rule, where the words of the statute are given their plain, ordinary meaning; the golden rule, which allows for a modification of the literal meaning to avoid absurd results; the mischief rule, which looks at the law's purpose to address the issue the statute was meant to remedy; and the purposive approach, which considers the broader purpose and intent behind the law. Let's explore the civil judiciary framework. The High Court is at the top of the framework. It handles substantial cases and operates in three divisions: Queen's Bench, Chancery, and Family. Below the High Court is the County Court, which handles all cases. The County Court categorizes cases into different tracks based on their complexity and value. First, the small claims track is designed for low-value, simple disputes up to £10,000. This informal track allows for self-representation with limited recoverable costs. Next, the fast track is for moderately complex cases valued between £10,000 and £25,000. This track features streamlined procedures and fixed timetables to ensure efficient case management. Then, we have the intermediate track, which handles claims between £25,000 and £100,000. This track balances complexity and efficiency with capped recoverable costs. Finally, the multi-track is for high-value, complex cases with no financial limit. It offers flexible, detailed case management and significant cost recovery. Let's look at civil dispute resolution alternatives. There are several methods for resolving civil disputes outside of traditional court proceedings. First, we have mediation. Mediation involves a neutral third party who helps the disputing parties reach a mutually acceptable agreement. The mediator does not make a decision but facilitates communication and negotiation between the parties. Second, we have arbitration. In arbitration, a neutral third party, an arbitrator, listens to both sides and makes a decision usually binding on the parties. Arbitration is more formal than mediation but less formal than court proceedings. Third, we have negotiation. Negotiation is the most informal method, where the parties involved directly communicate with each other to reach a settlement. This method gives the parties the most control over the outcome. These alternatives can often save time, reduce costs, and provide more flexible and creative solutions than going to court. Let's examine the criminal judicial structure. Criminal proceedings in England and Wales typically start in the Magistrates' Court. This court handles less serious offences and preliminary hearings for more serious offences. Cases are transferred to the Crown Court for serious offences. The Crown Court deals with serious criminal matters, including those that require a jury trial. Solicitors can represent clients in lower courts, such as the Magistrates' Court. However, they need additional qualifications to represent clients in higher courts, such as the Crown Court. Understanding the criminal judiciary's structure helps navigate the legal processes involved in criminal cases, ensuring that the appropriate court and legal professionals handle cases. In the legal system of England and Wales, both civil and criminal appeal pathways depend on the judge's rank and the court in which the case was originally heard. Permission is typically required to initiate an appeal. This ensures that only cases with a significant reason for review proceed. The Supreme Court, as the highest appellate court, handles the most significant public interest cases. The doctrine of precedent is based on the principle of stare decisis, which means that previous judicial decisions influence future cases. This ensures consistency and predictability in the law. There are two types of binding precedents: vertical and horizontal. Vertical precedents refer to decisions from higher courts that lower courts must follow. Horizontal precedents involve courts following their own previous decisions. Judicial decisions contain two main elements: the binding ratio decidendi and the persuasive obiter dictum. The ratio decidendi is the legal principle or rule binding in future cases. The obiter dictum consists of additional observations or comments made by a judge that, while persuasive, are not binding.